Good afternoon. Welcome to the second part of Holland Knight's New York Real Estate Trends webinar series. Today we'll be discussing converting rental apartment buildings to condominiums. I am Stuart Saft, the New York Real Estate Practice Group leader, and I will be moderating today's program, which could be called Everything You Always Wanted to Know About Converting an Apartment Building from Rental to Condominium, but Didn't Think to Ask. Joining me today are Richard Ferrari, President and CEO of Brokerage, New York City and Northeastern Region for Douglas Elliman, who will discuss the market for conversions. Kelly Maharaj, an associate at Holland Knight and former head of review at the New York Attorney General's office, who will discuss the legal issues in filing a plan and how to expedite the review. Third, John Gianangelo, Executive Managing Director, Douglas Elliman Property Management, who will discuss how buildings should be managed during the conversion. Fourth, Renee Kovic, a partner in Holland Knight and someone who has handled numerous conversions and will share her insights into how she dealt with problems that arose during the conversion. Fifth, Melissa Efron Mandel, a partner in Efron Mandel and Howard, and a landlord and tenant attorney who will discuss the landlord and tenant issues that arise in a conversion. At the end, we will take Q&A through the chat room. CLE credit will be available for this session, and you will be advised on how to obtain it during the session. I would like to thank Holland Knight for the use of their services and their webinar facilities, Mike Haig and Lauren Faulkner, who worked with us on this and all of the other webinars that we give, Kelly Thompson and Min Vu, who also assist in putting these programs together, Joe Gay, the real estate section leader, and Stephen Sumberg, the managing partner of Holland Knight. Let me begin by noting that since the enactment of the Housing Stability and Tenant Protection Act in 2019, the general consensus has been that conversions were not possible. This is only true as far as eviction conversions are concerned, but no one had done an eviction conversion in decades before the law changed. Non-eviction conversions are possible, legal, and we are still doing them. They are different, and the tenants have more control, but conversions still provide landlords with a way of being able to sell an asset to the residents and others who want homes in a city and state where there is a very real shortage of housing and a dearth of new construction as a result of actions taken by the legislature. For those of you who think that rent-stabilized tenants have no interest in buying their apartment, I could not disagree more. And I cite Rupert Yorkville as the prime example. Rupert Yorkville was a Mitchell Lama rental with significantly below market rents. I was repeatedly told that Mitchell Lama tenants would never buy their apartments and give up their cheap rents. Everyone who said that was wrong. We were able to sell 85% of the 1,400 apartments to the tenants by carefully structuring the offering and educating the tenants as to ownership of condominiums. We did it 20 years ago during the post-9/11 recession, and it can be done again today. And we will assist you in the process of doing it. I am now pleased to introduce Richard Ferrari, President and CEO of Douglas Elliman Brokerage.
Thank you, Stuart. Little bit of background on myself is that I joined the real estate industry in 1989 as an agent, and I remained an agent selling for Douglas Elliman and Brown Harris, and then back at Douglas Elliman. I'm going to say I was selling for about 33, 34 years. I've been president and CEO of Douglas Elliman's Northeast region for brokerage for the past 2 years. When I joined our industry, and Stuart will know this, Co-ops were about 85% of the inventory that was for sale, condominiums about 15%. Today, we're probably closer to 60% on co-ops, or maybe 65, and 35 to 40% on condominiums. Most of the early condominiums were buildings with 1 bedroom, small 2 bedroom studio apartments. The trend changed roughly 2002, 2005, with the emergence of 15 CPW, the Plaza Hotel conversions, and then, as we know, West 57th Street, Billionaires Row, the large apartments and condominiums came in and became competition for the large co-ops. Over the past 20 years, we've had very little new construction affordable to a New York purchaser of 1 bedroom, small 2 bedroom condominiums. And as a result, right now, there is a major need in the marketplace for condominiums, in smaller condominiums, not necessarily the 4 and 5 bedroom and 3 bedroom apartments, where conversions come into play. New York residential market is very strong. Okay, yes, it's never a good market in the eyes of an agent. We all know that. The negative news always takes the press, but reality is we are a very healthy, strong market. And the demand right now, there is a shortage of 1 bedroom, small 2 bedroom, and studio condominiums for sale. Lots of co-ops, as we all know, but the condominium market, you know, I hope, Douglas Elliman, you guys can convert into condos, because Douglas Elliman can sell them. Because the reality is the product that you may bring to the market by converting buildings to condominiums right now is the product that's needed. We don't need, for this type of apartment, you don't need all the super amenities a lot of the new buildings have. You know, you need a gym or a fitness room, a children's playroom. And what COVID taught us all is that any outdoor space public for a building is great, meaning a roof terrace or a garden. But the demand right now for the studio 1 bedroom and 2 bedroom condominium in Manhattan and Brooklyn is very strong. Stuart, you know, I'm here if anyone has any questions, but thank you.
Thank you, Richard. Kelly Maharaj will be next.
Hi, as Stuart mentioned, I worked at the Attorney General's office prior to joining the firm. So I just wanted to give a brief overview of the offering plan filing process at the Attorney General's office. You know, as Stuart had mentioned before, you know, in order to convert a residential rental property into condominium ownership, you have to file a conversion offering plan, also known as a Part 23 offering plan. This requires the help of many consultants. Owners or sponsors tend to hire consultants such as architects, engineers, attorneys like us, of course, insurance agents, and management companies such as John's company in order to help with the operations and preparation of the offering plan. Once the sponsor is able to get all this information from the respective consultants, the attorneys compile the offering plan and prepare everything for submission. In the recent years, sponsors have been given the opportunity to submit a CPS 11 application prior to submitting an offering plan, because it allows that sponsor to test the market. While it's not as broad as testing the market with a CPS 1 application in a vacant building, the CPS 11 application allows the sponsor, if granted by the Attorney General's office, to gauge the interest in any vacant units at the building. It allows the sponsor to discuss any sort of interest from the market rate tenants in purchasing their property, their units, and it also allows the sponsor to enter into reservation agreements with these market rate tenants. You know, it's limited in its scope that sponsors are only allowed to speak to the market rate tenants, and the AG typically provides guidelines with this, but it's a helpful tool for the sponsor to determine if they want to proceed with converting the plan. Once the offering plan is submitted to the Attorney General's office, the sponsor is also responsible to serve copies of these offering plan or red herring to the tenants at the property. The tenants are able to, with the red herring, the sponsor submits a notice to the tenants along with the senior citizen or disabled person election forms, because the regulations were amended a few years ago stating that you needed to include certain provisions in the notice with respect to senior citizens or disabled persons. So it's important that we include those representations in the notice. The notice also informs the tenants of the right to comment on the red herring plan. They can submit comments to the Attorney General's office. They can submit comments to the sponsor or sponsor's selling agent with respect to the plan. Once the service is completed on all of the tenants and they receive the red herring, the sponsor is now responsible for delivering an affidavit of service along with an affidavit that no excessive long-term vacancies are present at the building. This is a crucial part of the offering plan, because if there are excessive long-term vacancies, then the Attorney General's office will not allow the sponsor to proceed with the plan. Excessive long-term vacancies mean that there are vacancies for more than 10% of the units for periods of 5 months or more prior to the date the offering plan was submitted to the Attorney General's office, or the vacancy rate at the time of submission is double the normal average vacancy rate for the prior 2 years from submission. So sponsor essentially has to show that neither one of those situations occur. And in a case where there is a vacancy rate of over 10% or more, sponsor is able to, if sponsor has the opportunity to demonstrate that there are no excessive long-term vacancies, if sponsor can demonstrate that this is the normal, is not double the normal average vacancy rate for the prior 2 years from the date of submission. The AG typically looks into this and tries to verify this by reviewing the rent roll. They even pull Con Ed records to check utility use to confirm that these apartments are actually in fact occupied. There have been situations at my time at the AG's office that we have found that units were vacant. And then we couldn't proceed with the plan, but this is one step that the Attorney General really looks into. And it's something that sponsors should discuss with the council at the beginning of the preparation of the plan. Once the Attorney General confirms that the long-term vacancy, there's no long-term vacancies at the property, the AG will then issue deficiency comments at the 4-month mark, but they can also issue deficiencies after that, but they cannot issue deficiency letters after the 6-month mark. It has to be before that. When the AG reviews the offering plan, there are several rounds of deficiency comments, and this could take, over a year from the date that the Attorney General gets the offering plan to the date the Attorney General accepts the offering plan for filing. There are situations where this can be delayed, and Renee will talk about it later on about the issues that have come up throughout the process where, it could run from over a year and a half to get the offering plan accepted for filing because of things unknown and that come up in the middle of review. Once the offering plan is accepted for filing, at that point, the sponsor is responsible for delivering copies of the offering plans, the final black book, to the tenants. At that point, sponsor can start marketing the units and entering into discussions with both market rate and any rent protected tenants at that point, and whether they want to proceed with purchasing their unit. The regulations were amended back in 2019 that now, in order to declare the plan effective, even if a sponsor would have contracts for outside purchasers, in order to declare the plan effective now, sponsors need to get contracts representing 51% of the units that are occupied by bona fide tenants at the time the offering plan is accepted for filing. This requirement applies to buildings with more than 5 units. In buildings with 5 or less units, a sponsor can actually declare the plan effective with 15% of the units. And they can actually use a tenant to declare the plan effective that's in occupancy, or a purchaser who represents that the purchaser or a purchaser, their immediate family intends to reside the unit. Once the sponsor receives the requisite units in contract, then sponsor will, work with the attorney to submit the effectiveness amendment to the Attorney General's office. And the Attorney General's office usually takes 30 to 45 days to review and accept the effectiveness amendment. And once the effectiveness amendment is accepted for filing, at that point, sponsor really can proceed with going to the Department of Finance to get the condominium declaration and tax maps reviewed and eventually accepted and recorded. And at that point, the sponsor would be able to commence closings. So,
Kelly, are you complete?
yes, I'm completed. Yes.
Okay, thank you.
Mhm.
Next will be John Gianangelo, Executive Managing Director at Douglas Elliman Property Management.
Thank you, Stuart. From time to time, we participate in the senior managers meeting for Douglas Elliman Brokerage. So I always start my presentation by saying this is the most important thing in the meeting, which obviously it's not, because all brokers have issues with property managers. But in this case, I think the role of the property management company is very important. So I'm going to really speak on 2 separate aspects. One is kind of preparing the building for a conversion, and preparing the building for a conversion really is not all that much different than good property management if you have policies, procedures, and plans in place. The most important thing is the infrastructure of the building, whether it's the facade of the building, the roof, the mechanical systems, HVAC systems, electrical, plumbing, and most importantly too, elevators, because those are the things that affect everybody that lives in the building's lives. And especially in a conversion, it's what prospective purchasers and their attorneys that are evaluating the purchase, what they look at. As you all probably know, one of the good things about a conversion is that when there is a sale, 3% of the sale gets contributed to a reserve fund, in addition to the usual 2 months worth of working capital. So these buildings typically start out with a pretty good amount in reserve. And in addition to that, there's usually some work that goes into the building. It's usually well in advance of the actual conversion, but just in planning for that. So when you deal with all of those individual aspects of the infrastructure, you need to make sure the building is in compliance with all local law and building code requirements. That's critical, because when you start the conversion and there are issues, whether they're leaks or whether they're outages of services and the like, it is not beyond the realm where tenants in the building will report you to someone, which we'll talk about in the second aspect of my presentation. So in addition to that, you're going to probably require some improvements to the common areas, the lobby, whatever amenities that are in the building, gym, lounge, hallways, children's room. The things that Rich had said are really very, very important to having a successful conversion, and also figuring out how you're going to manage the process with the existing tenants utilizing those facilities. So that brings us to how we deal with residents on conversions. And what we found, and we've done several conversions, some of which Stuart has been involved with. And what we found is you really need to manage a conversion the same way you provide quality management service in a rental building. You need to pay attention to the tenants, because the tenants, they can be a source of referrals. They can be, it's inevitable that when you're showing apartments or when the brokers are showing apartments, they're probably going to run into people that already live in the building. And if you do not manage the building well or that process well, you never know what a tenant might say in an elevator, because they always know that there's a broker there and they know that there's a prospective person there. And as a general rule of thumb, what we tell our people is, in addition to regularly communicating what's going on in the building with the tenants, treat the tenants the same way as you do condo unit owners. Or prospective owners. To have an adversarial relationship with tenants is not going to benefit anyone, and in particular, the sponsor. I mean, you need to establish communication and the feeling amongst residents that nothing has changed when you've converted. You're still providing top service. You still want to get maximum rents, and you still want to take care of the building. Part of that goes to we tell our clients to perform the maintenance in these apartments the same way that we've always done it. Consider the fact that, if you start ignoring some of the service and hoping that you're going to get tenants to move out, it's going to backfire. It's just not a good thing to do. Again, in general, keep the relationship where it was when the building was strictly a rental. That is going to very much help you in the long run. And look, as much as practical, keep them involved, not with all the details, but kind of keep them involved in the process. Tell them what you're doing. Tell them what your plans are. The last thing you need is a group that organizes, that's going to try to fight you, that's going to, these days with social media, everything gets out there. So if you get an angry group that is unhappy about something, you don't need that information out there in places where it can hurt you. So that's basically it. I think communication is key. That's it. Thank you.
John, thank you. Next, Renee Covet. Renee, your mic is off.
That would help. Thank you. As we heard from Richard, Kelly, and John, there are many factors to consider when converting a rental building to a condominium. But one of the most important factors is the New York State Attorney General. And while a Part 23 plan, the regs provide guidance, there are a lot of other nuances that need to be considered when converting an occupied building that are not necessarily written in the regs. And I thought it would be helpful to go through a few examples of some of the buildings that we've converted, just to demonstrate what some of the issues are that could arise and how we got through them in all of these buildings. So if you want to go to the next slide, and then the next one. This is the Apthorpe condominium, which was 163 residential apartments plus a garage, retail, and professional units. The sponsor was a joint venture that had interests in both the US and Israel. And when we submitted the offering plan, the first thing that got held up at the AG was that the price point was over $1 billion. And it was the first time that they had to enter $1 billion into the AG system. So that's just a fun fact. And we can go to the next slide. So as I mentioned before, the sponsor was a JV ownership with interests in both Israel and the US. And when the plan was accepted for filing by the AG, an article came out in Israel that mentioned that the sponsor and the sponsor's principal was this Israeli investor who had an interest in the JV ownership, but was not actually listed as a principal of the sponsor. And somehow the AG's office got a hold of this article that was printed in Israel and opened up an investigation as to who the sponsor's principal actually was. Luckily, as part of our due diligence, when we submit an offering plan, we had read the JV agreement and all the ancillary documents, and we were pretty sure about who the principals of the sponsor should be. A principal of the sponsor is somebody who has day-to-day control in the project and also an interest in the entity. And the Israeli investor was a silent investor and had no control. But the AG wanted to make sure. And so they basically stopped sales immediately. And we had to prove that this Israeli investor was not actually a principal of the sponsor and was just, a silent equity partner. So one of the things to consider when you're doing a plan is who the principal of the sponsor is, who it should be, and how your LLC agreement is written, in case the issue arises. And like I said, we vetted it, and we were pretty sure about who it was before we submitted it, and we were able to provide the backup. What happened next was that because of this investigation, sales had stopped, and we had 15 months to declare the plan effective, and we were nearing pretty close to when we needed to declare the plan effective. And this was also in 2009 during the Great Recession. And somehow Douglas Elliman managed to find us purchasers, but we had to certify that these purchasers intended to live in the building. And in order to do so, a purchaser needs to fill out an affidavit. So before we submitted any of these affidavits to the AG, Holland Knight reviewed every single one to make sure that these purchasers would actually qualify as bona fide purchasers, so that there wouldn't be anything held up, and we would be able to declare the plan effective within the 15 months. Thankfully, we were able to get the effectiveness amendment through. I think Kelly had mentioned that it usually takes 30 to 45 days. In this instance, I think it took about 9 months to get the effectiveness amendment accepted, because the AG decided that they were going to interview every purchaser. There were a lot of foreign buyers in the building, and they really wanted to make sure that these purchasers were going to live in the units. So they did Zoom calls, they had phone calls, they vetted every purchaser, and then agreed that these purchasers qualified, and the plan was declared effective. So we were able to start closing. And then on a famous Saturday night in the summer of, I think it was probably 2012, but Stuart can contest that date. Stuart and I got a call that our client was about to start a litigation, and in the litigation papers, they were putting in a statement that was contrary to something that was in one of our offering plan amendments. And we said to the client, please don't put that in the litigation papers. We're going to have an issue with the Attorney General. They said, no problem. Everyone went on with their Saturday night. And by the following Friday, the lawsuit was filed. And of course, lo and behold, the statement was in there that we had said not to put in. The AG immediately stopped sales at the building and launched an investigation. And so we had to, again, go through the process of proving to the AG that, it wasn't actually contrary to what was in the amendment. And sales were stopped for months and during this. And so we finally were able to get the Attorney General to agree that we could revise the amendment and provide the proper disclosure, and we were able to continue with sales. So these are just a few of the issues that arose with the AppThorpe. At the end of the day, they were able to sell, and we were able to declare the plan effective and move on. We can go to the next slide. This is 275 West 10th Street, also known as the Shepherd. It is a building that has 61 residential apartments. And this is an interesting building, first of all, because Kelly was the head reviewer at the AG's office at the time. And so she was the one that actually reviewed the plan. And the first call that I got from her was a call that a lot of the tenants in the building were angry because there was a major gut renovation going on around their apartments, and their apartments had become uninhabitable and dusty. This is what they were alleging. And Kelly got the call and had to, make sure that things were actually, that the sponsor was doing the right thing. And so we went back and forth, and we provided our plans, and we gave notice of what we were doing. And Kelly, actually, we can go to the next slide. And Kelly said, I really want to see what's going on at the building. And so she actually arranged a site visit, and she met me at the building downtown, and we walked through the building for a few hours to look at all the construction, to see, the status of what the tenants' apartments looked like, and whether they could actually, get up and down, and whether they could really live there while this construction was going on. We were doing all the things that John mentioned, that John and Richard mentioned. We were adding a gym, a lounge, children's space. There was, we were gutting all of the vacant apartments, but they were actually doing it in a way that the tenants could live there. And that's a tricky thing to do. But after a few hours down at the building with Kelly, she saw what we were doing, and she agreed that we were doing it in a reasonable manner and allowed us to thankfully continue the work. So that's just another thing to consider when you're doing the construction with tenants living around you, to make sure that you're doing it in a way that the tenants are not harmed, and, they can live there happily. In this building as well, the AG did check the Con Ed bills to confirm that the units that were occupied actually had residents living there. So our plan, I don't think we got deficiency comments for about 6 months before we submitted it. And the Attorney General actually came back and asked us questions about the tenants. They were checking our long-term vacancy affidavit very thoroughly. And aside from just providing the rent roll, we had to provide lots of other documents to prove that the apartments were actually occupied. We can go to the next bill. This is 737 Park. Next slide. It's 103 residential units and 5 commercial units. The interesting thing about this building in particular is that our client called us when he was a contract vendee and he hadn't actually closed on the building yet, and said, this is what I'm planning on doing. I need you to prepare the offering plan and have it ready to submit the day after I close. And so we were doing our due diligence and putting our plan together and working with all the third parties before our client had actually even closed on the building. And so this made, checking the tenant files and going through all of those different nuances very, difficult, and we ended up having to go down to DHCR because a lot of the files were incomplete, and we really needed to make sure that we weren't going to have a long-term vacancy problem. But we were able to put a plan together, and the day after our client closed, we were able to submit the plan to the AG's office. So it's doable, and I think there was something, the timing just worked out that we closed and then we submitted the plan. So that was an interesting one. We can go to the next slide. The next slide is our CLE code. So if anyone is getting CLE credit, the code is HK 2305237445. This is the Belnord. The picture on the left is the building in 1909 when it was built. The picture on the right is the building as it is. This building is famous, and some might know it as the Arconia because it is the building that's used in the show Only Murders in the Building, which is a little fun fact. We can go to the next slide. It is 213 residential apartments and 2 commercial units. It looks very similar to the Outthorpe. It's only a few blocks away and has the beautiful courthouse in the middle. And again, it's the Arconia. So it was a fun building to work on. Thankfully, we didn't have as many problems. And, we got through the EG after going through, months of deficiency comments. And that's all. So if we want to go to Melissa.
Good afternoon, everybody. In dealing with tenants in a building where ownership is in the process of or considering condominium conversion, as landlord and tenant counsel, we find that the important steps are planning, knowing your tenants, knowing your tenant status, and working in a coordinated way with the team, with management, with condo counsel, with contractors if there's going to be work done in the building. And first, I'd like to say I echo 100% everything John said, everything in dealing with tenants. And in addition, I'm going to add a few more points from a landlord and tenant perspective. Knowing your tenancies. Do you have rent stabilized tenants? Do you have rent controlled tenants? Do you have rent regulated tenants? And of those, when are their leases set to expire? And are there renewal options in their leases? Knowing who your tenants are. Do you have professionals, families, roommates, senior citizens? And if we have senior citizens, do they have family members living with them? And if so, for how long? With respect to the status of the tenancies, if the owner has had the building or say management company in place for some period of time, this may be information already in the tenant files that the management already knows. But if not, we find that this is something that should be determined as early on in the process as possible, and that file documents, leases, renewals, registrations for rent regulated tenants, that's just the starting point, and that there should be a deeper dive into seeing if the apartments are as they're believed to be, if the deregulated apartments or market rate apartments, if they not only are deregulated, but if it's defensible, if we have the documentation and the information, if these are challenged to be able to show that they were not rent stabilized or rent controlled. Having accurate information at the beginning, or even knowing where your vulnerability are as to some tenants, is not only an aid in planning, but in helping to avoid missteps that could lead to harassment claims. Since the Housing Stability and Tenant Protection Act, which many of my clients refer to as the dreaded HSTPA, certainly removing any residential tenant from possession is an issue, but there still are legally permissible means of doing that if that is helpful to the process. And when and if that's helpful to the process, we as landlord and tenant attorneys rely on condoing counsel as to when it's helpful, if it's helpful, and which apartments it might or might not be helpful. With market rate or non-regulated apartments, one of the changes in the law that's relevant is that as of now, if you have a non-rent regulated apartment and the lease is coming to its natural end, the landlord has no obligation to renew that lease. That may change if we get fair cause eviction, which has been talked about for a while. But as of now, the law is you do not have to renew. However, since the Housing Stability and Tenant Protection Act, if a landlord does not want to renew a lease for a market rate tenant, or probably not that relevant here, but wants to renew it at a rate higher than 5% of what was previously paid, the tenant must be given written notice of either the non-renewal or the increase. And depending on how long the tenant's been in possession, that notice can be required as long as 90 days out. And if the notice is not given, the lease term continues until that notice has been given and has expired. Another legally permissible manner to recover possession, if that's what the interest is a rent stabilized tenant who is not primarily residing in the apartment. Also, breaches of the lease, such as non-payment, subletting without permission from ownership, and even failing to provide access can be the grounds in some circumstances. But again, knowing the status of your tenants, whether they're rent regulated or not, is critical in determining this. And then who your tenants are. We found that, again, building staff may be the best source of information for this, but sometimes early on in the process, engaging a private investigator to see if the tenant of record is actually who's living there, and to find out other information that might be helpful in dealing with tenants in the future. Sometimes that's warranted. And once we have an understanding of the status of the tenancies and the composition of the tenants, then everyone, the client, the managing agent, counsel on the conversion, and landlord tenant counsel can work together to strategize and address issues. Is there a value in vacating any of the apartments? And for that, we rely on the condoing council. We don't want to have too many vacant apartments, but some it might be helpful, and when that might be helpful. And then if there's going to be significant construction, and if so, how will that affect the tenants in possession, including whether or not we're going to need access to occupied apartments, and how we're going to go about doing that. So one very important point we found, and going back to what John said again, is that having and knowing in advance who your contact person is going to be, who's going to be dealing with the tenants. If you're going to give the tenants anything in writing, that be vetted very carefully by everyone involved before it goes to the tenant, because sometimes saying the wrong thing unintentionally can have a very negative effect. And in this regard, I'm keeping in mind that also, as Renee mentioned, so construction with excessive dust or debris, blocking of areas, excessive disruption of services, all that can be, under the current law, a form of tenant harassment, which of course we need to avoid. And then also to be considered is the option of buyouts. And if that's going to be an option, again, we would rely on condo counsel as to when that process can and cannot be started, and what would be, from the client, what would be more valuable if there are certain units that, because of construction, it would be more valuable to have vacant or not. And in this regard, once we're told that from condo counsel that it is a time where tenants can be approached, then I mentioned that since 2018, in the city of New York, under the administrative code, it is considered harassment for an owner to contact a tenant about a buyout without first giving them written notice with certain points, including the purpose of the contact, that it's on behalf of the owner, letting the tenant know that they have the right to reject the offer and continue living in the apartment, that they have the right to seek the advice of an attorney, and that they can advise the owner in writing that they don't want to be contacted. And if that happens, then ownership cannot, or their agents are not to approach them again for 180 days, except in certain circumstances. And summing up, in dealing with tenants in buildings where condo conversion is considered, planning and working in a team with all the other professionals, I would say, is what we find to be the most effective. And I am finished.
Thank you, Melissa, Renee, Kelly, John, Richard. That's a lot of great information. Let me add to it by saying that we're all guided by the Martin Act, which, as Kelly indicated, is New York securities law. The Martin Act requires that purchasers, including tenants, be given full disclosure of all material facts. And so before we start working on a plan, we will seek all material facts, engineers' reports, accounting reports, financial statements. We examine the limited liability company or partnership documents going all the way up the organizational chart until we get to human beings, because we want to know as much about the property as we possibly can. all the stories that Renee told you about the difficulties that she had in various plans, basically it's the tip of the iceberg. And the reality is, yes, there are always issues that arise. The Attorney General's office is very vigilant when it comes to the securities offerings, and particular Part 23 offering plans. We know that. We go into this process knowing that, and all the stories that Renee told, I can tell you, every one of the plans went through, all the sales occurred, money was paid to the developers. We had other situations, for instance, at Manhattan House, which was 5 landmark buildings. We had 2 different tenants groups form. We had one tenant group representing the rent stabilized tenants and a separate tenants group representing the market rate tenants. We dealt with the 2 tenants groups. Ultimately, we resolved the issues so they couldn't interfere with the plan going through. In fact, with all the problems that Renee pointed out that we had in the Apthorpe, at the end of the day, 15 of the tenants purchased their apartments because they recognized that there was value in owning the apartments. What is really at the base of everything that we do when it comes to, particularly with regard to Part 23 offering plans, is that it's all about strategy. There's probably no aspect of the law that involves more strategy than this is, because you're walking a fine line between not harassing the tenants, not getting a feared call from the Attorney General's office saying they're starting an enforcement hearing, and ultimately getting the conversion to the finishing line. And that's what we do. I have to tell you, Renee and I were at a partners meeting in Florida when we were contacted that Kelly Maharaj was looking into one of the plans, and she struck terror in our hearts just knowing that Kelly was on the move. This was long before she joined us at the firm, and she was tough. She wanted to see everything. She wanted to understand everything. And she and Renee became very close during the process, but she was demanding. And that's one of the things that we respect about her, is that she knows her work and she's really good at getting it done. We've had other complications. We had one 400-unit building where an angry tenant was starting fires in the building that we had to deal with. Somehow, somebody decided this must have been the sponsor doing it. So we wound up playing detective to find out who was starting the fires. In point of fact, it wasn't even a tenant. It was the roommate of the tenant who was angry about the tenant wanting to buy the apartment, so the roommate would have to move out. Again, we had to play detective to get to the answer. We are very much aware during the entire process of how important tenant protection is to the Attorney General's office, and so we go out of our way to make sure that our clients do not step over the line. But it's important that this be done. I just want to make a couple of general comments, and that is that we talked all about condominium offering plans, but you can still do co-op offering plans. They have fallen out of popularity, except when it comes to ground lease property where it can't be a condominium. But there's a reason for using a co-op plan in the current environment. Unlike a condominium plan, if you do a co-op plan, you can leave debt on the property. If you leave debt on the property, it means that the tenants can pay less for their apartments because you don't have to pay off the debt on the building. And so that helps to keep the conversion affordable. As Kelly and Melissa both said, you have to avoid, and John in fact said it also, you have to avoid harassing the tenants or even the appearance of harassing the tenants. There are posting notices that have to go up every 30 days during the conversion until the plan is declared effective, and on the 80th day, and then on the 90th day, those postings have to go up. Because the tenants under the Martin Act have to know how close you are to being able to declare the plan effective. At some point, the tenants are going to form a tenants association, and sponsors, particularly first-time sponsors, always fear when the tenants form a tenants association. And frankly, it's a good thing when they form a tenants association. First of all, because there's so much incorrect information that floats around about offerings, that having them form an association, hire counsel, hire an engineer is positive, because you want to find out what the issues are as early in the process as possible. And you need to have somebody that you can negotiate a deal with. You can't go out and negotiate, if you have 100 tenants in the building, 100 separate deals, because all of the tenants have a right to get the same deal. So you have a tenants association, and you have somebody that you can talk to who understands the process, and that also helps you get to the finish line. So as I said, there's a lot of moving parts in doing a Part 23 plan. We've all been through it. We all understand what has to be done. The housing HSTPA, as I said earlier, has not killed conversions. They made them a little bit more difficult, but what in life hasn't become a little bit more difficult in the last few years? It's just something else that has to be taken care of. But let me just say that if you have any questions at all about the conversion process, the ability to convert a building, what the limitations are, please don't hesitate to call any of us. If it's about landlord-tenant issues, Melissa is fabulous. If it's about management or marketing, John and Richard are available. And of course, our team, me, Renee, Kelly, we're available to answer your questions. As I said, it's a complicated process, and it's confusing, and there's all manner of things that go on, but we've seen them all, and we've been through it all. And Renee's comments about our Saturday night call one summer was true, and the client hung up on us and said, "I'm not going to do it. I'm going to take the language out of the brief." And we learned that the language wasn't taken out of the brief by a call from the Wall Street Journal asking about it, and then we knew, what the next couple of months were going to be like, but we got through it, and that's the important thing. Not that problems arose, but we got through them. In any event, would any of the panelists like to make any closing comments or additional comments to what they already said? You're welcome to retake the virtual microphone. Okay, then. Well, thank you all for joining us. As I said, this was the second of a 4-part series of webinars on real estate trends. Last month, we did a groundbreaking webinar on adaptive reuse of buildings. We, the Holland Knight team, have converted 1.2 million square feet of office space in Manhattan to non-office use in the last decade. You heard me correctly, 1,200,000 square feet of office space was converted to hospitality, residential, charter schools, medical facilities, and all manner of uses. This month, of course, is on conversions. And in June, we're doing a webinar on buying failed condo projects and what you can do to restart the process and get the unit sold. We've done a number of these over the last 2 years, and they turn out highly successful once the issues have been resolved. And then the next one in the series will be about co-op and condo hotels. In any event, thank you for participating. We appreciate your involvement. And as the Sims clothing ad used to say, an educated consumer is our best customer. Thank you.